TV legal correspondent Chanley Painter is with us. She is in Washington. Also with us, Seth Berenzweig. He's a trial attorney in Washington, D.C. Thank you both for being with me still. Let me start off with you, Seth, and we're talking a little bit about the age of some of these appointees. Very young. I mean, they have a very long life on the court should they be confirmed. Should there be some age requirement? Because if you have let's say, a president, like a Republican president, who put someone onto the court, that's a lifetime appointment. Very long time to be on the court. And then there's also the question of, is there enough experience there? Certainly she's qualified, but is there enough experience there to sit in such a heavy seat?
Well, you're indicating one interesting aspect of the judge's background here. And let me just say at the outset that there's really no question in my mind that she is well qualified. So I don't quibble with that. But the thing that's unique in one aspect for this nomination is that she has been a judge for about 3 years. And although there are certainly dozens of opinions that she has participated in, and there are a number of aspects that people will be able to derive with her judicial opinions that they'll be able to cover in the hearing tomorrow, that's a relatively short period of time for someone who is going to be appointed to the United States Supreme Court. So, she's eminently qualified. There's no question about that. But the fact that she only has about 3 years worth of judicial experience is a very interesting element, especially when you foot that with the point that you're raising, which I think is a very important one, that this is, as we know, a lifetime appointment. And, fast forward 30 years from now, how is that originalist interpretation of the Constitution going to fit with society 30 years from now? Let's take, for example, even as we sit here today, an originalist interpretation of Fourth Amendment and privacy issues. Well, when the Constitution was written, when these aspects of these other aspects in the amendments were written, there were no cell phones. And folks many centuries ago didn't exactly have browsers on their cell phones. But what happens if you're talking about complicated issues in the realm of technology, social media, the prevalence of judicial oversight of technological advances and digital communications? There are things that are going to be applied under the Constitution as it relates, for example, the zone of privacy interest, where by definition, they're not going to be necessarily applied in an originalist principle. So it will really be fascinating to see how these balances occur, especially over the course of time.
Yeah, that's always interesting to see how that's applied. I know in one instance, the social media was determined to be the new town square. And that's how they sort of interpreted it. So I found that interesting. Chanley, you're younger. You're someone who's going to be under the effect of decisions by Amy Coney Barrett for many, many years going forward, longer certainly than I will. I want to get your opinion. Do you think there should be an age limit? Or do you think it's okay for someone that young with that limited experience to be on the court and now sit there for the rest of their lives, 40, 50 years down the road?
I'm okay with it. She's 48 years old, and like we keep saying over and over again, her experience, she was a 15-year law professor at Notre Dame, when lots of research and writings and studying the law and Supreme Court decisions and theories and her legal philosophy. So she's no question qualified for this position, whether we agree or disagree with what her philosophy may be. And, for President of the United States, you have to be 35. That's really young. JFK was probably one of the youngest presidents, and he's probably some people think he's probably one of the best presidents in history. You never know. I don't think age should be the only determination of someone's experience or how they'll do at the job. I think there's other factors that obviously need to weigh in to make sure the person is qualified, they have the experience and expertise to do the job. And then if they are able to serve, like she may be able to serve 30, 40 years, that's just, I guess, the benefit of her job. She has job security, right?
That's right. And it's certainly going to be quite a legacy for President Trump. Now, let me go to you, Seth. There's a little known part, sort of a behind the scenes part of judges where they need a quorum to even hear cases. And that's also an area that she might have a very distinct effect on in terms of just the types of cases that get to the court. The court has rejected a number of cases that are controversial. They might end up in front of the court now.
Yeah, absolutely. And I think that, as we all know, there is not an automatic right of judicial review to the Supreme Court. There is a filing of a writ court to exercise its plenary authority and discretion to make a determination of whether it wants to and is willing to accept the case under the court's internal rules and procedures. And the fact that she is going to be now bringing a new voice to that very critical front end of the process is going to be very critical, not only with respect to the fact that she has her own judicial philosophy, but now she's going to be able to have a voice as to what kinds of cases are even going to be brought into the docket. So it's not even automatic that the cases that get appealed, of course, will ever be heard by the Supreme Court, but she's going to really, presumably, when she gets confirmed, which she probably will, then she will be integrated into that entire process, and then she will have an important voice even before a case makes its way into the courtroom for oral argument.
Now, Seth, we've heard a lot of discussion about the health care. We've heard a lot of discussion about abortion. What other areas do you see her having an effect on? Or because there are a number of other areas that she has very serious and very different opinions on that could affect the outcome of cases.
Well, how about the possibility that she's going to make a ruling on the election that's coming up a few weeks ahead? I agree with you that the lightning rods that are really being focused on, for the most part, relate to the questions of Roe v. Wade, and then as it was subsequently handled in Planned Parenthood versus Casey, and also the Affordable Care Act, which is going to principally end up really resting on whether or not the provision that may fail is severable or not, and then it may end up collapsing the entire enactment. But I think that we're really looking at quite a distinct possibility that she may be ruling in a Bush v. Gore type of context that really may end up having an impact on the election. Of course, there are an array of a lot of other issues that will be before the Supreme Court. There are very active cases as it relates to corporate and employment law. The court is often brought in to assess the core purposes and the outer limits of certain protections that are afforded to employees, applications of arbitration clauses, and whether someone can be forced into arbitration or not. So there really is an array, not only with respect to these cases that deal with social justice, but also business law. There are some very critical issues that the Supreme Court regularly has on its docket. So issues relating to corporate employment law, business law are going to predominate as well.
Now, Chanley, I know you were outside for a lot of the time today talking to different folks. Were there any other issues that came up in conversation? We know, of course, again, healthcare and abortion. Anything else people showed a particular interest in or were worried about?
That's an interesting question because those were the main topics. We saw, the signs of ACA and pro-life, but there weren't, that seems to what got people here in the first place, right? That's why they traveled all over the nation to be here for those hot topic issues. But there is another, I think, issue that a lot of people are drawn to with her, especially conservatives who are in support of the Second Amendment. She has this dissent that she wrote in 2019 where she believed that even if you're, convicted of a nonviolent felony, you should still be able to have the ability to own the gun under the Second Amendment rights. So I think that's another issue that really galvanizes a lot of the conservatives in her camp.
Absolutely, Chanley. I think the gun rights issue, also the religious right, it's a great day for them when she gets confirmed because there are a number of rights that they felt began to infringe upon those who have sort of religious grounded beliefs. And so we might see some of those swing in the other direction. All right, stand by, guys. Thank you very much. You heard Justice Roberts talking about meeting with senators. One of the little things that you may not know is that once a president chooses a nominee, that nominee then goes up to Capitol Hill and spends a lot of time meeting with as many senators as possible just to talk, get to know each other, get to see what their concerns are, and they can have these conversations, which helps the process along. So a little inside baseball there. All right, still with me to discuss is trial attorney Seth Berenzweig. Now, Seth, I want to talk about those little conversations that they have. Oftentimes, I know a couple of justices didn't make the rounds and then didn't get confirmed. So those meetings are extremely important when they go up to Capitol Hill and they're making the rounds and they're talking to all the senators. Those are real important in this process.
I agree. I think that the aspect of a personal rapport with these folks is very, very critical and to try to not only understand where they're coming from, but what are their concerns and what's their perspective in terms of where they would like to see the direction of the court. And I thought it was very interesting that you have that 2005 footage for the discussion with who would become Chief Justice Roberts and his talking about meeting the senators and really developing a rapport with them. I also thought it was interesting where he had themes that seemed to be similar to what was happening today, right? It's almost like the old saying, the more things change, the more they stay the same. We're talking about current judicial themes of trying to follow the law, just as he said, calling balls and strikes and staying within the letter of the law as opposed to trying to step towards something that might be akin to judicial legislation. But sometimes those issues are more difficult than they may appear to be. So, for example, when we're talking about abortion rights and the processing of how Roe was treated in the Casey case, at the end of the day, the Supreme Court has changed that standard into a substantial burden standard, which recognizes that states have the right to implement rules and regulations affecting abortion clinics. So the justices of the Supreme Court will often say that they don't have the intent of overturning Roe, but yet how will Judge Barrett apply Casey as it relates to different rules and regulations that may affect someone's access to an abortion? So you're hearing some very common denominators and some very well-respected themes, but it just depends, how does it play out at the end of the day?
Yeah, you mentioned something that often doesn't get mentioned in these abortion arguments, in many of these guns rights cases. It's about states' rights. I mean, a judge may feel that a lot of these decisions should be left up to the states, and you'll hear that a lot from conservatives and Republicans, no?
Absolutely. And the whole aspect of the law under the 10th Amendment of that which is not applied and reserved to the federal government is reserved to the states is of itself a really fascinating aspect of different opinions that have emanated from the Supreme Court and aspects of federalism that tie directly into that. That really contributes very much to the texture of judicial thought. And the thing that's so interesting that we touched upon a bit earlier is that there is a relatively thin judicial record to see how this nominee takes a view towards these kinds of issues. It's not that it's sparse or that it's not there, but 3 years of decisions through the federal circuit court is not a very large volume. So when we're listening to the questions that are going to be coming up over the next couple of days, there'll certainly be discussions of her decisions, but also her speeches, things that she has participated in and co-authored, certain articles, as well as certain ads where she was a participant in things that related to abortion pertaining topics. So it should be very fascinating to see how these hearings progress over the next couple of days.
Yeah, I've always found it very interesting, this whole concept of federalism versus states' rights. It's a real important area that they'll be watching very closely. I'm sure some questions will come up about that tomorrow. Also wanted to mention precedent. We haven't talked about that. We heard Justice Roberts talk about the idea that it's a court of precedent and this idea of stare decisis. How do you think that plays into the judge's decisions, and how much should it play into a judge's decision?
Well, it should play very, very heavily. But frankly, as I've gone through my years of being a litigator, I think precedent is in the eye of the beholder because, and I promise I won't beat this drum any longer, but when you see how Casey versus Planned Parenthood has been applied to really loosen the rules of the game in terms of state rights to be able to provide certain regulations as it relates to access to abortion clinics and a whole variety of other issues as well. It's very interesting to see how the concept of stare decisis applies. And sometimes that can be a little bit of a misleading topic because it really depends upon how it's applied under the rubric of the case at hand. But generally speaking, one of the things that we can certainly count on is that Judge Barrett will probably say over the coming days that she has a lot of respect for prior decisions and that she will try to adhere to the letter and the spirit of the law, as well as the prior decisions that have been issued by the Supreme Court.
Yeah, she certainly will. But she has said that she doesn't think that it should be a constraining factor on the court, meaning if the decision is wrong based on her reading of the law, she has no problem overturning precedent. All right. Well, thank you very much, Seth Berenzweig. I really appreciate your time today, and I really appreciate you being with us. Hopefully, you'll come back and join us again.